Pa vam Srbi pozdrav po granati šalje, Zagreb je daleko, Sarajevo još dalje.
Hello everyone, my name is David Herboot.
And my name is Philip Abraham, and today we will be talking to you about the Bosnian genocide case of 1993, titled Application of the Convention on the Prevention and Punishment of the Crime of Genocide, a landmark case ruled by the International Court of Justice.
We will take you through this case by first exploring the key parties involved. Second, we will discuss the relevant historical context and legal mechanisms to help situate the issue. Following this, we will examine the arguments put forward by each side. We will end our analysis.
The case before us involves two key parties.
The applicant or plaintiff of the case is Bosnia and Herzegovina,
And the respondent or defendant of the case is the Federal Republic of Yugoslavia, now known as Serbia and Montenegro. In order to understand the relevant context and legal mechanisms related to the case, it will be helpful to explore the history of the case. The root causes for the case can be traced back to the aftermath of the Second World War, in which Balkan states under the Yugoslavian Republic began to experience growing rifts and nationalist tendencies. This was exacerbated by Serbian leader Slobodan Milosevic, who helped foster discontent between Serbs and Bosnians.
A war erupted in 1992 when Bosnian President Izetbegovic declared Bosnia independent after a national referendum. Bosnian Serbs responded to the declaration of independence with violent reprisals. Bosnian Serb forces, acting through the paramilitary group Republika Srpska, conducted various atrocities through Zvornik, Foka, Vizgrad, and Srebrenica, in which thousands of Bosnian Muslims were massacred. Let us now explore arguments put forward on each side. But before we begin, it will be instructive to briefly look at the facts of the case. Bosnia brought the case forward to the ICJ in 1993, alleging that Yugoslavia breached the Genocide Convention.
The suit claimed that Serbia breached the convention by committing genocide against Bosnia's Muslim population. The court looked at three parts of the convention. First, the undertaking to prevent and punish genocide in Article 1. Second, the definition of genocide in Article 2. And third, the phrase, responsibility of a state for genocide in Article 9. In terms of the legal context, Bosnia and Herzegovina asked the ICJ to determine whether the state of Serbia was in breach of international law. More specifically, whether the state of Serbia was responsible for genocide during the 1992-95 war in Bosnia under the terms of the 1948 UN Convention on the Prevention and Punishment of the Crime of Genocide. Of key concern to the court was the following. Are parties under the Genocide Convention bound by the obligation under the Convention not to commit, through their organs, persons, or groups whose conduct is attributable to them, genocide and the other acts enumerated in Article 3. And Article 3 is important because it outlines the acts related to genocide that may be punishable.
Now, in order to answer those previous questions, the court examined several issues and issued rulings that establish key legal precedents. 1. States can be liable. Serbia argued that the Genocide Convention does not provide for the responsibility of states for acts of genocide. If it is the case, to what extent should the state be held liable if these atrocities were conducted through non-state actors, such as paramilitary forces? 2. It's hard to prove. The ICJ found that these atrocities were not enough to prove the necessary specific intent to eliminate an entire group that is needed for a genocide conviction. Despite evidence of atrocities and ethnic cleansing in Bosnia, as well as evidence that the Serbs received military assistance from Belgrade, Bosnia failed to prove that Serbia's leader at the time set out to physically eliminate Bosnia's Muslims and acted to carry out this plan.
The court arrived at its decision in the following way. The judges of the ICJ determined that the conduct of any state organ is considered to be an act of the state under international law. This is a rule of customary international law found in Article 4 of the ILC Articles on State Responsibility. However, there is no evidence that the Serb forces were de jure organs of the Republic of Yugoslavia. Why? Well, the court was unable to determine whether the organs that took place in the massacre were part of the Yugoslavian army or that the state leaders had anything to do with it. It was indeed evident that the defendants were providing financial assistance to Serb forces, but that does not automatically make them de facto organs of the state. In order to understand why this is the case, it may help to look at the complete dependence theory. Under complete dependence theory, it is possible to attribute to a state the conduct of persons who, while they do not have the legal status of state organs, are de facto organs of the state, on the theory that they are under strict control by the state. The judges explained, however, that Serb forces could not be regarded as mere instruments through which the defendants were acting through, or as lacking any real autonomy. The conduct of persons can also be said to be an act of the state under international law if the person is acting under the express instruction of the state. How do we determine this?
The judges claim that it is not necessary to show that the persons who performed the acts were in a relationship of complete dependence on the state, but it has to be proved that they acted in accordance with, or under the effective control, or under the overall control of the state. In order to help them move forward, the judges employed a series of tests showing that a state had complete control of all operations. However, it does not require showing that every operation by the group was under the supervision of the state, only that the state was in general control. Despite this, the overall control tests have serious flaws. The judges claim that it is not necessary to show that the person who performed the act were in a relationship of complete dependence on the state, but has proved that it has acted in accordance with or under the effective control or under the overall control of the state. In order to help them move forward, the judges employed a series of tests. The overall control test, which was drawn out of Nicaragua versus the United States case, requires showing that a state has had complete control of all operations. However, it does not require showing that every operation by the group was under the supervision of the state, only that the state was in general control. Despite this, the overall control test has serious flaws, in that it broadens the scope of state responsibility beyond the fundamental principle of international law, that a state is responsible only for its own conduct. For this reason, the test was considered unsuitable. Lastly, there is no evidence that Serb forces were under effective control by the defendants. Therefore, the persons that conducted the massacre were not organs of the defendant state, and the defendant is not responsible under the international law for the massacres.
Lastly, some authors have claimed that this case raises the larger issue of post-conflict reconciliation. How is this the case? Well, countries operate on two levels, government to government and people to people. And as demonstrated by Western Europe after World War II, long-lasting peace cannot be achieved merely through state treaties or reparation agreements and other legal instruments. Divided nations have to be brought together in the end on a more personal level. And cases such as this pose a challenge to parties that were harmed as a result. And it will be interesting to see the outcomes of what this case